Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review. My name is Jim Santelle, and yes, I'm your host for this hour and also the second hour of our weekly weekend broadcast on all things government, law and justice related here on the broadcast stations of Civic Media. I am honored, I'm delighted that you have chosen to spend some time with me and my terrific producer, Max, as we together with you engage in discussion about those latest breaking news stories in the areas of rule of law. And boy, do we have a lot of that from just this past week, including just in moments before we go on the air on this weekend. We're going to talk all about those. And of course, as we do in every broadcast, inviting you to be a part of that important discussion. You can call in at 855-752-4842. That number, once again, 855-752-4842. You can also text in. You can drop comments, questions, inquiries of me, also in the Civic Media Dropbox. Be a part of our discussion. Be a part of our involvement with you here on Amicus, a law review. Amicus, once again, that's the legal word, the Latin word for friend, sometimes joining the phrase amicus curiae, meaning friend of the court. The notion is that we are your friend in terms of providing with information, insight, something you don't otherwise know about what's going on in the area of law, and that is our commission here on our weekend broadcast. Once again, lots to get to. Let me tell you about the syllabus this weekend on Amicus, a law review. It is full of rule of law related stories and events, and again, some of them breaking days ago, some of them quite literally hours ago as we go on the air here in Radio Park, Racine, but going out to broadcast stations throughout the state of Wisconsin and beyond in the United States of America. And yes, indeed, that is the focus of a lot of what's going on in the rule of law this weekend. We're going to be spending some time talking about the authorities, the opportunities, the options that various branches of government have to affect our lives and our livelihoods. And if there is one big takeaway, one big lesson to be culled from our discussion this weekend, it is the role of federal judges, and yes, other judges as well, but especially federal judges in serving as guardrails, standards, protections of our Constitution, of our laws here in our nation, here in the state of Wisconsin. You may recall well that in late January, right after Donald Trump began his service as our president, we spent a lot of time talking about those various mechanisms already in place by virtue of our Constitution, the laws, the statutes of our land that prohibit any particular branch of government from being overreaching, from doing things that they cannot do, the checks and balances, you know those well from grade school and from high school and from college and other things that you may have been engaged in educationally throughout your life. The checks and balances, the rule of law requires, of course, that there are limitations on all the branches of government. And indeed, we talked at that time about three of those limitations on an executive branch that may choose to go beyond its assigned capacity to do the work of you and me. And indeed, we identified three of those. We identified United States attorneys, these people appointed by a president upon the advice and consent of the Senate to serve as the local federal law enforcement officers. We identified grand juries, branches of the courts, not the executive branch, branches of the courts, 23 people gathered in every single one of the 93 districts throughout our nation and our territories to decide whether or not particular indictments should be issued, determining probable cause. They're also a check on the executive branch and indeed on the Department of Justice. And then we also talked about the important role of federal judges deciding whether or not various actions violate or do not violate the laws of our nation, including our Constitution. We don't know a lot about what's going on with grand juries right now because, again, under Rule 6 of the Federal Rules of Criminal Procedure, those proceedings are not public, they're private. We don't know about the extent to which grand juries have been checking any actions by this Department of Justice when it comes to proposing indictments for political reasons, which is the great concern that is out there. Donald Trump committing, as have others, to going after his political rivals, people with whom he does not see eye to eye. We don't know about that just because, again, grand jury proceedings are private. But we perhaps will know about that down the road if indeed particular targets, their attorneys, particular defendants find themselves on the receiving end of grand jury subpoenas and other proceedings there. We know a little bit more about the United States attorneys, including at least one of them in the District of Columbia, who sure seems to be bent on doing exactly what the president wants him to do. We'll see what the other U.S. attorneys do as they come into office in the weeks and months ahead. But this weekend, especially focusing on the third major guardrail, the third major standard that is out there to ensure that a president, in this case Donald Trump, but any president under any administration, does not run afoul of the Constitution and of the laws and of the administrative procedures, all those things that are in place by virtue of our electing a Congress that decides what the law is, that tells us what the law is by virtue of passing legislation. Those pieces of legislation, of course, if they're to become law, have to be signed by a president, but they become the law of the land. And federal judges, and in particular district court judges, in recent weeks and days, and even, yes, hours, are responsible now more than ever before for putting the brakes on many, not all, but some of the things that Donald Trump and his administration have been doing, proposing, finding in the context of what are called temporary restraining orders, enjoining the administration from doing various things that it wants to do. This weekend, talking about the role specifically that federal judges have been taking, specifically trial court judges. We haven't seen a lot of this percolate up to the appellate level. And certainly we're concerned as well about the United States Supreme Court. They're also federal judges, justices in their case. And we'll talk a little bit more about the commission given a president to do perhaps exactly the kinds of things that Donald Trump has been doing in these first 20 days or so of his presidency. We're going to go back again as a part of our review, not only talking about federal judges, but the commission given by the United States Supreme Court right before the 4th of July last year, a number of months ago, in that major case, that constitution-changing case that gave to presidents not only immunities when it comes to crimes committed in office, as stunning and shocking as that should still sound to all of you, but also talked about the power and the need for a very strong executive branch. Needs to act quickly, needs to act decisively, needs to act in greater power, in greater dimension than the other branches of government. I'm going to read to you again during the course of our broadcast this weekend exactly what the Supreme Court has said about that, giving life to much of what Donald Trump and his administration have been doing, telling this president that he can do things that no other president in the history of our nation, 238 years, has been given authority to do. He's been acting on it, and the check, once again, at least in recent days and hours, has been federal judges saying, no, you can't. No, you can't do that. Of course, the jury, as they say, is still out on much of this. Why? Because there are promised appeals of those district court judges' opinions and judgments going up to appeals courts, maybe one day reaching the Supreme Court once again. But right now, once again, judges serving as the guardrails in America. And then we're going to spend some time talking about the other major rule of law event this past week, and that is we have a new Attorney General. Her name is Pamela Bondi. She was sworn in on Wednesday of this week. And following up on what we talked about just last week while Pamela Bondi was still going through the confirmation process, you recall well that we talked about these major changes affecting already the Civil Rights Division, shutting down cases, prohibiting the lawyers there from going ahead with consent decrees when it comes to policing in America. We talked about the movement of attorneys outside of the Civil Rights Division into other areas, including sanctuary cities, protections, that is, protections for the government and the Trump administration's view that those sanctuary cities should not be doing what they're doing. We talked about the honors program, the way in which these incoming attorneys had their employment situations canceled as a result of what was going on. We talked about the firing of prosecutors, which have increased even since the time of our last broadcast. Firing prosecutors who were involved with Jack Smith in prosecuting that now dismissed case out of the District of Columbia, charging the now president at that point, also private citizen, but former President Donald Trump for his involvement in January 6th. Also firing the prosecutors in Jack Smith's team who were responsible for prosecuting that documents case coming out of Mar-a-Lago. Since the time of that, promises to fire more prosecutors, and indeed promises made good on, as prosecutors involved in the January 6th insurrection rioters have also been given their pink slips in the past week, principally by the U.S. Attorney in the District of Columbia, who has told them that their services are no longer necessary. And also talking about this major policy inside the Department of Justice, telling U.S. attorneys as they sit in their offices now, as they come into office in the coming weeks, that they should investigate and prosecute local and community law enforcement partners if those partners fail to follow the dictates of the Trump administration when it comes to immigration policy. We talked about all of that last week, and there has been more even in the weeks since that time. We'll talk about Pam Bondi's investiture. We'll talk about the comments that she made that department attorneys serve Donald Trump, not the people of the United States of America. I'll contrast that with Barack Obama and my own experience with him and Eric Holder when I was a United States attorney. We'll talk about her promise to investigate more the prosecutors involved in cases that the president does not like presently from his past. We'll talk about her establishing some new task forces in the area of religion. We'll talk about her shutting down some things in the area of environmental enforcement and national security. We'll talk about all of those kinds of things. We'll talk about her work to stop the work against Russian oligarchs who are operating in this nation. And we'll talk also about what's going on right now with the FBI, again, at the hands of Emile Beauvais, the Deputy Attorney General, the acting Deputy Attorney General, when it comes to special agents also involved in the January 6th investigations. All of that happening just this past week. All of that coming up in our ambitious but achievable agenda here this weekend on Amicus, a law review. This is Amicus, a law review. My name is Jim Santelle, your host this hour and next hour. Max and I taking your questions, your inquiries, your comments, your observations at 855-752-4842. Being part of our discussion this weekend here on Amicus, a law review. A big rule of law broadcast this weekend, talking about the executive branch, talking about the Department of Justice, which is a part of the executive branch, talking about the FBI, which is a part of the Department of Justice, talking specifically about judges, the role of federal judges recently in checking Donald Trump on many of the things that have animated these first 20 days with breakneck speed. At the very end of our broadcast, we're going to talk about a district court judge in the District of Columbia, Superior Court of the District of Columbia, something that she did with respect to the Proud Boys and some engagement with a congregation, a black church there in Washington, D.C., now in charge, believe it or not, of the Proud Boys name and the copyrighted merchandise and other things of its symbols, now in the responsibility of a black church there in Washington, based upon the work and the decision of a district court, a trial judge in the Superior Court of District of Columbia. I'm going to save that story for the very end, but once again, emphasizing the role of judges when it comes to checking not only government, but also private parties, individuals who may engage in conduct violative of law. In that particular case, a judge interceding and making some important decisions after Enrique Tarrio and the Proud Boys vandalized that black church in Washington, D.C. We'll tell you what happened in that particular case, but we're going to begin by doing a little bit of inventory. It's a lot. It's a lot of things going on right now. A bit of inventory just to set the stage for the kinds of things that we have seen over the period of the past 20 days or so, the first 3 weeks of the Trump administration. Not all of these are directly rule of law, justice related, but all of them in one way or another defying legal limits at a minimum, raising questions about the authority of a president to act, and in many cases simply acting unconstitutionally, as federal judges are beginning to find. All of them probably given strength and given emphasis by a Supreme Court that back in July of last year told all presidents, including this one, that they've got an awful lot of power. Donald Trump exercising that power now in many different ways. Let me give you just a laundry list of the kinds of things that he has done. This first one started arguably even before he began to be the president. You recall well that he ordered the Justice Department really on his first hours as president, but even before that, not to enforce a legislative ban on TikTok for 75 days, and to notify the app and its business partners that defying the law is no criminal offense. Well, in fact, that law established by the Congress, by a bipartisan Congress, finding that there's a privacy concern with TikTok, there's a national security concern with TikTok, a bipartisan Congress passed legislation fairly decisively barring TikTok from operating in the United States unless and until there's a buyer identified, until its Chinese owner sells it, and giving a president some authority to extend that if indeed there is a buyer. I recognize fully that the issue about First Amendment rights when it comes to TikTok is one of those things that reasonable people can disagree on. That's a good thing. We enforce and we observe and we embrace the First Amendment in all things that we do. Nonetheless, the law of this nation was that TikTok going out of business, and indeed it did, you may recall, on January 19th. The president, contrary to the law, regardless of what you think about whether TikTok is a legitimate First Amendment exerciser of rights here in America, nonetheless, the president directing the Department of Justice not to enforce the law with respect to TikTok, one of the first things he did as the president, virtually on the same day, required blanket temporary freezes on most foreign aid. The longer that lasts, blocking, again, congressionally improved spending. It comes into greater intention with something called the Impoundment Control Act. President can't do those kinds of things after the Congress has spoken and told the president that he, one day, perhaps she, is obliged to exercise his responsibilities, her responsibilities consistent with the law. Did the same thing with respect to a domestic grants freeze. The Office of Management and Budget, OMB, was ordered agencies to carry out a blanket temporary freeze up to $3 trillion, with a cap with a T, $3 trillion in domestic grants and other government spending. The freeze has already been temporarily blocked by 2 courts after plaintiffs raised challenges to that, including some of the things called the Administrative Procedures Act and, yes, indeed, the First Amendment. So we've got some federal judges stopping that from happening as well. USAID, very much in the news as late as just this past week, and indeed late in the day on Friday. He moved to dismantle the agency and fold its functions into the State Department, making it under the rubric of Secretary of State Marco Rubio. Again, violation of the USAID Constitution, if you will, the legislation establishing it, and structuring that agency as a standalone agency, not subject to the oversight and review of the president. We'll talk more about what a federal judge did late in this past week. Inspectors General. The president summarily fired 17 inspectors general, the watchdog officials who hunt for waste and fraud and abuse in our government agencies. The law says that presidents have to give Congress, once again, 30 days notice and a written substantive rationale, including detailed and case-specific reasons before any removal can be happening here. Violation of the law, once again, Mr. President, when it comes to firing inspectors general. The National Labor Relations Board, this one hasn't gotten a whole lot of attention, but he summarily fired a member of the independent agency before her term was up. And it paralyzed the NLRB that does an awful lot with respect to labor in our country, leaving without a quorum. Well, a law says that presidents may only remove board members upon notice and hearing for neglect of duty or malfeasance in office, but for no other cause. That's what the law says. That's what Congress once again said. The president acting in violation of the law in firing that member of the independent NLRB. Federal prosecutors already made reference to those, summarily firing prosecutors involved in cases against President Trump himself, and of course the January 6 rioters already pardoned by the president or given commutations. Civil service job protections, as we have long discussed on this broadcast, against arbitrarily and without basis firing federal workers without good cause, without reason, without hearings before something called the Merit Systems Protection Board. That's the mechanism for addressing these kinds of things. The president taking upon himself to do these things unilaterally, firing federal prosecutors, firing also, if not now, certainly in the future, firing probably FBI agents subject to the same kinds of MSPB protections, Merit System Protection Board, those kinds of things going on in violation of the law. You recall well, all of this was started in many ways on his first days by declaring, the president did, that the Constitution's 14th Amendment no longer should be interpreted as granting citizenship to babies who are born on U.S. soil, contrary to the clear language and the interpretation of the 14th Amendment for all of its years, ever since it was passed in the wake of the Civil War. Long-standing understanding the 14th Amendment does, in fact, grant citizenship to those infants. All of that happening again in the first few weeks of this presidency. Many things all suggesting a president engaging in lawless behavior. When we come back, we'll talk about what we think are the predicates for this. How does Donald Trump get that authority? And it comes from, yes, indeed, the Supreme Court. All of that when Amicus, a law review, continues. is Amicus, a law review. My name is Jim Santelle, your host this hour and next hour as well, joined in the studio here in Radio Park by my wonderful producer, Max. And together we're taking your phone calls at 855-752-4842. You can also be in touch with us by dropping a note, a comment, an observation, a question in the Dropbox, Civic Media. And we are talking this weekend in our broadcast all about the rule of law, checks and balances. In our first segments, identifying a laundry list, very summarily, not a lot of detail there, believe it or not, about 10 or 12 different ways in which the current president, Donald Trump, is running afoul of established, not just principles and mores and ways of doing things, the models of our nation, but also running afoul, arguably, as federal district court judges are telling us, of the Constitution and the laws of our land. Many, many different ways, domestically, foreign actions, and a lot of the responses by federal judges happening almost in real time as parties who are aggrieved by the things that the president is doing run into federal court and say this is in violation of the law. Do something to stop it. And federal judges have been responding almost unanimously in various areas. We're going to be focusing upon at least 4 of those in this broadcast, ways in which the federal district judges have entered what are called temporary restraining orders. That is, temporarily preventing Donald Trump, temporarily preventing the administration from going ahead to pursue these various things, including everything from birthright citizenship, revocation, to NLRB appointments, to prosecutors, to foreign aid and domestic aid freezes, all kinds of things. Again, those TROs do not stay in place indefinitely. They're subject to follow-up hearings. And indeed, there's been at least one of those when it comes to that birthright citizenship issue that we'll talk about this weekend as well. Federal judges, among the guardrails, the standards, the ways in which checks and balances still work in America, even if the executive branch engaging in violative conduct, even if we have yet to see whether U.S. attorneys out there will also enforce or not enforce the laws of our land. Not a lot of visibility yet on whether grand juries are preventing investigations of people inappropriately pursued already, arguably, by this administration. And that will also lead to the other subject we'll talk about later in our broadcast. That is our new Attorney General and the many things that she is already doing, creating and stopping various task forces, creating various mechanisms, new policies with respect to national security and our environment, all kinds of things going on, as she said, as the Department of Justice serves Donald Trump. Keep that in mind. I'll contrast that to what my boss, Eric Holder, and my ultimate boss, the former president of the United States of America, said to U.S. attorneys back in his administration, that administration, of course, Barack Obama, telling us that that we don't serve him. We don't even serve the government. We serve the people of the United States of America. Contrast that to what our incoming new Attorney General has already said about the ways in which fealty and allegiance to Donald Trump is all what the Department of Justice is about. Let's get back, however, to the predicates for where this is coming from. Where does Donald Trump receive the authority to do this? Well, in part, he says it's political. In part, he continues to make reference to the fact that he was given, as he says, a mandate by the American population way back in early November. And based upon that mandate, he is doing the things that he's doing. That's what he's telling us right now. The people of America told me to do these things, and that's what I'm doing. I'm making good on campaign promises. Question whether or not many of these things, including, for instance, the USAID issue, which is looming large right now, whether that was a part of the campaign at all or that was an add-on. He did begin to talk about it in December of last year. But putting aside the timing of all of this and the focus of all of this and the breakneck speed with which all of these executive orders and directives to hire and fire and to impose various restrictions with respect to money and policy and practice, putting aside the speed and the inaccuracy and the failure of this to be supported by law, the question is, where does Donald Trump get the authority to do this? And I would offer, as I have before, that we can look again down Pennsylvania Avenue, beyond the parking lot there on Capitol Hill, beyond the parking lot of our Capitol building, Go across the street there to First Street, First Capitol, and look at the United States Supreme Court and what they did and what the Chief Justice did on July 1 of last year. We've talked a lot about this on this broadcast. I would offer to you that the specters that we posed back then, the ghosts, the concerns about the implications of this major case, Trump versus United States, had not yet been seen under the Biden administration, because you had a president until January 20th who was not invoking these amazing powers given to a president by the Supreme Court. And this president plainly doing just that in ways that we have seen, probably many ways in which we have not yet seen. What did the Supreme Court do again way back in July? Seems like a long period of time ago. It's not. The language of what I'm about to recite for you remains the law of this land. This is Trump versus United States, July 1, 2024. A majority of the Supreme Court, admittedly just 6 members, written by the Chief Justice, scathing dissents by 3 other members of the Supreme Court, as you know well, Elena Kagan, Ketanji Brown Jackson, Sonia Sotomayor, fearing for the future of the democracy, fearing for the future of the republic, they wrote, and dissenting not with respect to what the Supreme Court had done. The Supreme Court, in addition to establishing for the first time in our history the notion that a president is indeed above the law, and that concept in itself probably given Donald Trump an awful lot of support and reason to do what he is doing. Those immunities, both presumptive immunities, going into the notion that we're going to presume that a president is immune for virtually anything that he or she may do. Absolute immunities when it comes to the Department of Justice. Again, a focus of a lot of this coming out of his White House in recent days. And again, the Bondi administration, the Bondi Department of Justice itself. But beyond the specifics of that major, horrific, catastrophic decision coming from our Supreme Court and the pen of our Chief Justice, John Roberts, back in July, are the first pages of that order. They're somewhat overlooked when we think about the overall impact of that order, saying, yes, Mr. President, you're immune from prosecution. Because as an antecedent to that, as a predicate for coming to that conclusion, the Supreme Court went back and revisited the notion of executive authority, lots and lots of pages before then, and cobbled together, based upon some very, very random, and yes, they exist, but not in the way that the Supreme Court put them together, all sorts of little bits and pieces to establish an all-powerful executive branch of the sort that we have not seen before. Let's hear what the Supreme Court told Joe Biden. Let's hear what the Supreme Court has told Donald Trump and is telling presidents in the future. Until this law, until this decision is somehow rescinded or put on the dung heap where it should be of Supreme Court decisions, here's what the Supreme Court is telling our current president. Said this: the president occupies a unique position in the constitutional scheme. Well, let's stop right there. One of 3 branches, and yes, unique in terms of the executive authorities, but not unique in terms of sharing responsibility with other authorities. Nonetheless, the Supreme Court is saying the president occupies a unique position in the constitutional scheme as the only person who alone composes a branch of government. Now, that's certainly technically true. It is physically true. Is that a basis then for vesting in that singular person all of the authorities that are to come? Offer that just the opposite would be true, because there's no check and balance. You don't have 435 members of the House of Representatives who check each other. You don't have 100 members of the United States Senate. You don't even have 9 members of a Supreme Court. You've got 1 person alone. Supreme Court says that's the basis for giving that person a huge amount of power. There's even more. The framers, John Roberts tells us, sought to encourage energetic, vigorous, decisive, and speedy execution of the laws by placing in the hands of a single, constitutionally indispensable individual the ultimate authority that, in respect to the other branches, the Constitution divides among many. Oh my goodness. Let's read that again. Let's take that in one more time, because that's the language. That's the language that is giving Donald Trump from his view, his authority to go ahead and do these things, yes, as quickly as he's doing these things, but also with the power that he's doing it. Supreme Court told him that the framers of our Constitution envisioned that our president would be energetic, vigorous, decisive, and speedy in the execution of laws by placing in his singular hands constitutionally indispensable individual rights, the ultimate authority to do these things that in other branches is divided among other people. That language should also make the hair on the back of your necks stand up. The Supreme Court goes on, says the framers also deemed an energetic executive essential to the protection of the community against foreign attacks, the steady administration of the laws, the protection of property, and the security of liberty. Now, lots of that you can't object to. A lot of that's in the Constitution. We envision that. But in the wake of that notion that all of those powers are to be executed with the energy and vigor and decisiveness and speed and muscularity that the Supreme Court envisions, that's what we're seeing now. This is the Supreme Court's language coming true. The purpose, John Roberts went on to say, of a vigorous and energetic executive is to ensure good government. For a feeble executive implies a feeble execution of the government. You have to have vigor. You have to have energy, John Roberts tells us, because if you go in the opposite direction, you get bad government. And a bad government implies feeble government, and we can't have that, he said. Went on to say, the framers accordingly vested with the president a supervisory and policy responsibilities of the utmost discretion and sensitivity, has to make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. There accordingly, John Roberts went on to say, exists the greatest public interest in providing the president with the duties of his office. Appreciating, again, this is John Roberts in Trump versus United States, July 1, 2024, appreciating the unique risks to the effective functioning of government that arise when the president's energies are diverted. Unless they can be completely focused on these things, don't divert the president, because if you divert the president by proceedings that might render him unduly cautious in the discharge of his official duties, we have recognized presidential immunities and privileges rooted in our constitutional tradition of the separation of powers and supported by our history. That's a lot of language there. All of that saying that indeed, because there's a risk of feeble government. There's a risk that a president might be diverted by things like, say, checks and balances, by people saying, Mr. President, you can't do that. Mr. President, you're not above the law. We can't have that, John Roberts is saying. And because of that diversionary possibility, we have to have this energetic, vigorous, decisive, speedy, muscular executive that we have not seen. We have not seen until this presidency and the last 20 days. We're reminded here on this broadcast of the commission, the responsibility that the United States Supreme Court holds as well, sending this instruction. And let's be clear, this is the law of the land in America. This is not some random musing by John Roberts and 5 other colleagues, admittedly with scathing, horrific dissents by other members of the Supreme Court, horrific only in the sense of horrified by what the majority has said and done. This is not some random musing. This is not a law review article. This is not a piece appearing in a law review in the Wall Street Journal, in the New York Times, and any other newspaper. This is not something that's posted on social media. This is the law of the land, and we follow it. And indeed, I would offer here, as we begin to think about what Donald Trump is doing under the rule of law and whether there are still guardrails, this is the commission by the United States Supreme Court, your court, given to Donald Trump. And we continue, we'll talk about some of those guardrails coming in from federal judges and the possibility that much of this may get back to that same Supreme Court at some point in the future of our nation. Right here on Amicus, a law review. This is Amicus Law Review. My name is Jim Santelle. We're spending a lot of time necessarily talking this weekend about Donald Trump and his decisions in many, many areas of government operation, both domestically and overseas, issuing executive orders telling people inside the administration what the Trump administration now demands of them, even as members of his cabinet fall into place, including our recently invested Attorney General Pam Bondi. We're going to be spending some time in our next hour talking about the continuing work that she has done, continuing the work of a fellow named Emile Beauvais, who's been acting as the acting Deputy Attorney General. We'll talk about what Pam Bondi has done just in this past week to further implement the plans and policies, the law enforcement, the rule of law policies of this president that also include all of these other things which we've already taken very, very broad and superficial inventory of in the areas of, yes, social media and TikTok and inspectors general, the National Labor Relations Board, federal prosecutors, birthright citizenship, all kinds of things, USAID, grant freezes domestically, foreign, all kinds of things out there that almost defy listings because they're changing all the time, and more of them happening again at breakneck speed. Gets us back to what the Supreme Court has said, which is that we anticipate, according to the Supreme Court, that an executive, a president, should act with that breakneck speed, energetic, quickly, nimble, muscular, doing all those kinds of things with vigor and decisive action. We're getting that. We're getting that, Mr. Chief Justice, and you commissioned the president to do just this. However, we also have a system of laws in America, and many of the individuals, many of the groups out there who have felt aggrieved by these various actions of the president and his administration in all of these areas have gone into federal court. And what do? You go in and you file, yes, that's right, a lawsuit. You file a civil complaint. All of these are civil in nature. None of them is criminal, because only, of course, United States attorneys and only grand juries can issue grand jury indictments, of course, coming out of the federal system. But citizens, all of us, groups, individuals, can run into the federal district courts, the 93 of them nationwide and in our territories, run to the district courts and go into the clerk of court's office and say, I'm filing this complaint. That's the legal name for the document that initiates a civil action. And in those civil complaints, outlining exactly what the president has done in a particular area, identifying the nature of the executive order or the directive coming out of the White House, and identifying then the ways in which, according to the petitioner, the plaintiff in that civil case, the defendant, the whether it could be a particular agency, more often it is actually Donald J. Trump in his official capacity, sometimes other members of his cabinet, the defendants in those cases, identifying the ways in which they are running afoul of the laws. That's all put forth in a document. That's called the complaint. And accompanying those complaints are also what are called petitions for emergency relief, asking the judges to whom those cases are randomly assigned in various districts around the nation, please act quickly. Why? Because if you don't, bad things will happen. You need to preserve the status quo until we can get in front of you in a full trial, a full days long, certainly hours long at a minimum proceeding, to explain to you why it is that what the president has done is in violation of the law, violation of the Constitution. So right now, Judge, that's the request that goes along with the complaint. Please stop this from happening. Direct the White House, in your role as a federal judge, checks and balances, the kinds of things that we do understand in the Constitution. Under Article 3 of the Constitution, you have got that right to check another branch. You've got the right, as one of our first Chief Justices said, to decide what the law is and tell us what the law is, and to decide on the legitimacy of actions by an executive branch. That's what goes on when the petitioners go into federal district courts and ask for immediate relief. And that's what we've seen in recent days in virtually all of these areas. In the area of birthright citizenship, in this area of shutting down the USAID, in the area of this incentive program for getting rid of government employees, telling them to resign now, we'll continue to pay you through September, but leave now. And yes, indeed, as late as when we're coming on the air here this weekend, another judge telling Elon Musk that indeed he has to keep his hands off all of that Treasury information that relates to the ways in which the Treasury Department intersects with millions, hundreds of millions of Americans on a regular basis. A federal judge now temporarily stopping that. Of course, the important notion there, temporarily doing this until such time as the parties can come in and argue these cases at greater length, identifying exactly what's happened, the impact of these cases upon those particular plaintiffs, the groups that they represent, the individuals serving as plaintiffs. That's the process that's right now going ahead in many ways, big and small. And yes, it is indeed difficult to keep track of all of it. We're going to identify again just four of those. I mentioned them already, in which federal judges, once again, in America, doing their duties under Article 3 of the Constitution to provide some check and some balance. Now, again, as I invoke the Supreme Court and its rule, what can happen? Well, these judges can indeed, they can do what's called vacate a temporary restraining order. They can decide not to issue an injunction of a permanent or even preliminary nature. They can say, you know what, my initial stay of all this action that was improvidently granted, I'm going to let the government go ahead and do just this. Highly unlikely that that will happen, given some of the things that the judges have already said when it comes to access to these Treasury information blocks, these incentive programs, the USAID issue, birthright citizenship. An awful lot of those judges already saying, you must be kidding. Where are the lawyers? This is so overtly contrary to the law that everybody should know that this does need to be restrained, does need to be stopped. But there's a chance that when these cases go ahead, the judges can do more to rescind, to refine their orders that they're already entering. Of course, all of these orders are then subject to appeal to the various circuit courts. We've talked a lot about those here on this broadcast. You go up to the Fourth Circuit, you go up to the DC Circuit, to the Ninth Circuit, to the 11th Circuit, the Fifth Circuit, the 10th Circuit, and say, you know what, that lower court judge, he got it wrong, she got it wrong. And you get before a panel of judges and you argue the case there that the lower court decision was wrong or right if you are the successful litigant at the lower court level. And yes, indeed, all of this underscores the prospect that all of this work right now being done at district courts could ultimately see the light of day where? Back at the United States Supreme Court. United States Supreme Court that, again, has given an awful lot of authority to our president in this major decision. As Amicus, a law review, continues, we're going to talk about specifically what's happened in those four major cases, lots and lots of litigation out there. Federal district court judges, I would offer the heroes of this weekend broadcast who are providing the guardrails against unconstitutional behavior. Stay with us for all that discussion.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle. I'm your host for the second hour of our broadcast this weekend, addressing in ways that we often do the trappings of the rule of law, the invocations of that in real time in America. Much of this, if not all of this, in response to the breakneck speed with which our president is issuing executive orders in a great variety of areas, financial, domestic, international, having to do with the basic ways in which we live and pursue our livelihoods in our nation, and the roles of federal judges in addressing whether those things that the president is doing are constitutional, legal, contrary to, or in compliance with the laws as passed by the Congress. An awful lot going on right now in the federal district courts of our nation, perhaps very soon in the appellate courts of our nation, and maybe, yes, indeed, back in the Supreme Court, when one or more of these challenges to what Donald Trump is doing may reach that high tribunal, and requiring the justices once again to determine whether or not they meant what they said back in July when they talked about this hugely muscular, energetic, vigorous, decisive, speedy executive that's necessary as opposed to a feeble executive, which is not consistent with the Constitution. That's what John Roberts said back in July. All of this, a fascinating time to think about these things in terms of rule of law and justice and the processes of government, but also recognizing that there are real live human beings inside all of these cases. They're real live human beings, citizens, residents of our nation, that are affected dramatically by what is being done. And so we never overlook that aspect of that. And that includes, again, this decision early on, unilaterally, by our president that the 14th Amendment doesn't mean what it says and says what it means. Birthright citizenship, he said, no longer exists, goes into court, many cases around the country. Let's talk about just a couple of them that have percolated up, in which, again, courts have said that no, people in America born here in our nation, they do in fact have a right to citizenship. 150,000 children born each year, and therefore entitled to the benefits and the rights of citizenship in our nation. That's what the Constitution says. And absent that, they will be stateless. Absent that, some of them, if not all of them, finding themselves without the benefits of citizenship. 150,000 children every single year has an impact upon human beings. Well, for the second time in just about the past week, a federal judge has issued, get this, a nationwide across the board, every state, a preliminary injunction, more than just one of those TROs, the temporary restraining order I talked about before, to block President Trump's effort to end this concept of automatic citizenship for babies born on U.S. soil to undocumented immigrants. This decision was handed down again by a judge we've heard from before. His name is Judge John Cowanauer. It was issued in Seattle. It came a day after another judge in Maryland across the nation did the same thing, also issuing a nationwide injunction, a nationwide ban against President Trump's executive order seeking to ban this concept of birthright citizenship. Now, the judge in the Seattle case, again, had previously entered a TRO. Now he's making it permanent. He said this, he said, the Constitution is not something with which the government may play policy games. If the government, Judge Cowanauer said, if the government wants to change the exceptional American grant right of birthright citizenship, it needs to amend the Constitution itself. And that's the judge saying, Mr. President, you do not have the capacity unilaterally to issue an executive order and change the Constitution as you like. Now, the current Justice Department, yes, under now Attorney General Pam Bondi, has said that's going to appeal that order where? To the Ninth Circuit. That's where the appeals from the district court in Western Washington will go. But all of this, of course, underscoring the unanimity of federal judges out there who are scratching their heads and saying, what's going on there? Birthright citizenship, again, guaranteed under the 14th Amendment. And ending that, of course, would require amending the Constitution. Judge Cowenauer was unpersuaded by the arguments, although there was skeletal made by the current administration in front of him. He said it's become ever more apparent that our president, he's talking about Donald Trump, for him, the rule of law is but an impediment to his policy goals. Those are strong words coming from a federal district court judge. The Maryland case, also national in scope. The Washington decision, again, joining along with Maryland and others out there. There are more hearings coming up in the days just ahead in other courts around the country, all of them bolstering this notion that the federal judiciary feels very strongly that what the president has done here, or attempt to do here, is wrong and cannot go ahead, not only for legal purposes, but also in the interests of those hundreds of thousands of children born and therefore getting citizenship in our country. This Seattle decision, of course, signals that the federal judiciary believes strongly in the Constitution, that their guardrail role is in place. It is significant that the judges who are entering these orders are appointed by Republican and Democratic presidents. We shouldn't have to say that. We shouldn't have to say that in America, but it underscores the unanimity, the nonpartisan nature of these decisions being issued, and indeed telling Donald Trump that he is wrong, that he cannot exercise his authority as he has been doing it, and that this energetic and decisive action that the Supreme Court has apparently given to him does not extend to changing the Constitution, Mr. President. That's the guardrail that we're seeing just in recent days and weeks. We will continue to see that as more district judges enter initial injunctions, TROs, permanent injunctions, and as these cases percolate up to the circuit courts as well. Let's talk about another federal program. This one's a bit more curious because it's a part of the administration's overall effort to try to reduce the overall federal workload and workforce in particular that has a huge workload. We've talked a lot about the importance of civil servants in our system. They're the ones who make government go. They're the ones who are responsible for, in their independence and their apolitical, nonpartisan approach to work, should be doing the work of you and me, ensuring that we are served according to the law without partisan interference. The administration is saying we'd like a lot of you to leave. Please leave. And if you leave, this is the promise initially given by the administration. If you leave now, we'll guarantee that you're paid through September. That particular package, of course, getting a lot of attacks once again in the federal district courts. We'll get to what has happened coming out of a federal judge's pen in Massachusetts in just a moment, but also underscoring the lack of legality for even that. An awful lot of people in Congress, other places, saying that that is violative, once again, of congressional action. We don't simply fire people and yet continue to provide them with an economic benefit of employment they no longer have. That's simply violative, contrary to the basic understandings, frankly, of any business, including that of the United States of America. So what happens is that the government, through the administration, announces this thing called the fork in the road plan. Presumably, you've got a fork in the road now. You can either continue to work for us, maybe we're going to fire you, we're not sure, or you can leave now, and we'll pay you for some of the months just ahead. Detailed in an email sent to about 2 million federal employees just in recent times. It offers workers, once again, the chance to resign and be paid through the end of September without any congressional authorization. Nothing out there to support that as well. Labor unions picking up on that, members of Congress picking up on that and saying, can't do that, Mr. President. Challenging the legality of this, going into court, urging employees not to accept the offer ahead of a deadline of just this past week, saying that if you do resign, and indeed, according to the press secretary coming out of the White House, whose name is Caroline Leavitt, you've begun to get to know her a bit. More than 40,000 federal workers have already accepted that offer, for which there's no predicate. That, according to the White House press secretary, she said, we encourage people still to do that. Federal workers in the city should accept this very generous offer, she said, adding, we'll find highly competent individuals who want to fill these roles. In other words, leave leave your civil service positions. We'll find somebody else to come in, and we'll presumably train them in the jobs for which you have already been trained. Don't worry, go on with your lives, leave now. That's the encouragement from this administration, once again, to undermine the civil servant workforce in America. Well, what happened, of course, is that you've got various groups, including labor unions, going into court. And one of those cases is in the District Court of Massachusetts. It's a federal district in and of itself, in addition to being the Commonwealth of Massachusetts. And a federal judge named George O'Toole Jr., U.S. District Judge in the District of Massachusetts, stopped the Office of Personnel Management from moving forward with the program until Monday. Put a stay on this. The deadline was previous to that, late this past week. The offer, which had been set to expire at 11:59 on Thursday, again, a part of this sweeping effort to attack, if you will, to reduce the federal workforce overall, plainly a part of this thing called DOGE, pursued by Elon Musk without any authority in and of himself. We'll get back to Elon Musk in just a few moments, and something that happened just this weekend with respect to his authority. All of this a part of their attempt to cut the size of the federal government and to do it in a draconian way. And again, is almost certainly unsupported by legislation. Well, the judge in Massachusetts, again, postponed that deadline, saying, well, you can continue to sign up for it, but I'm going to have a hearing on Monday afternoon about all of this, put basically a TRO in place to enable people to continue to sign up for this if they wanted to do it, but promised a hearing on Monday afternoon to look at all of this, to figure out whether or not this program offering federal workers this incentive to quit, whether this makes sense. Stay tuned, plainly. Watch this space to see whether or not this federal judge, George O'Toole in Massachusetts, follows the plan, the pattern of other federal judges saying, wait a minute, Mr. President, do you have authority to do this? What's the argument in support of your authority? Isn't this the kind of thing that only the Congress can do? And yes, Congress has great authority when it comes to establishing the trappings of civil employment, a huge amount. They established not only the agencies for which they work, the independent agencies, but also the ways in which they're compensated through our federal government. We'll see what the judge in Massachusetts does. We'll talk about other judges in America also pushing back on the initiatives of this presidency when it comes to the constitutionality and legality of these many executive orders here on Amicus, a law review. This is Amicus Law Review, spending a lot of time talking about the status of these many breakneck speed orders being issued by the White House, changing the ways in which government works and not to the better. Let's talk next about USAID, the United States Agency for International Development. A bit of a programming note here. Yesterday, that is on Friday of this past week, had a great opportunity to sit in the Dom Salvia show as the host of that and spent the greater portion of that broadcast talking all about The United States Agency for International Development is generous and what it does as a predicate to understanding what the president and the Secretary of State have been doing with respect to that agency. I commend to your attention, to the extent you want to go back and pull up that podcast of the Dom Salvia show just on Friday of this past week, a huge discussion with many of you in the community expressing outrage about what is happening with the United States International Agency for International Development, an independent agency. And that's where we began. Important to understand, yes, if you had to describe them in terms of their function, are they executive in nature? Yes, they are. They provide an awful lot of support for our international partners out there. We'll get to that in just a moment. But it's an independent agency, not subject to oversight and review direction of the presidency. There are a lot of those agencies in America in our constitutional development budget of over $50 billion. Sounds like a huge amount. It is, but also represents somewhere around 1% of our total national budget. About 10,000 employees worldwide. Let's get to their particular purpose. What do? They provide disaster relief to some of our partners and even countries in which we don't have strong partnerships. Poverty relief in nations needing that support in dramatic ways. Technical cooperation for global issues, including things like the environment, environmental justice overseas as well. Bilateral initiatives enabling, for example, the representatives of USAID to tap into the resources and the human resources of our own agencies in providing support for our international neighbors. Socioeconomic development. This one's huge. Enabling foreign countries, again, with our assistance, yes, our economic support, but mostly our human resources support, engaging with communities, the neighborhoods in which these USAID offices are located in countries around the world, quite literally, Africa, Asia, Latin America, Middle East, Eastern Europe, and other places, all of them stationed around the world to try to promote the interests of justice, yes, but also, again, focusing upon human beings, providing them relief, suffering from disasters and poverty and economic blight, all kinds of things out there, socioeconomic development, technical assistance, financial assistance, public and private partnerships in those foreign nations, all of that, developing the ability of foreign countries to do these things under what? The encouragement and the support of, yes, indeed, the United States of America, and also sending the message that, yes, indeed, ally with us, and we will continue to support you. Ally with others who may seek your attention. We're the ones giving you that attention, right? And so the Chinas and the Russias that are out there, those are not the folks who are necessarily getting the support that these countries necessarily, they're not giving the support these countries need, even as they compete with us in the international scheme for the attention of emerging democracies, emerging nations. There's also a huge diplomatic, international, and yes, indeed, national security interest in what we do overseas. Top of the list, humanity, but second and third down the road, it's in our national interest to have presence in nations around the world and to help our friends around the world. What has happened recently? Well, we know well that in recent times, the president has attempted to, and it appears this weekend to be pretty successful in bringing to an end the United States AID. The plan was to put 2,200 employees on paid leave. And recall, nearly all of those agency workers have brought a huge amount of confusion caused by this, as the president's directed, again, through his edicts, that all of these employees begin to dismantle the USAID offices around the world, shutter them. We know that in Washington, D.C. alone, right there in D.C., that the USAID office has basically been darkened. The lights are off. The signs outside the building have been covered. And this, of course, about a part of the president's plan to bring USAID to its close. Also a part, of course, about his overall view that the USAID, among many other agencies, bloated, too many people working already. Well, all of that, of course, getting an awful lot of attention internationally. an awful lot of people in the international community, including our allies, saying we need this support. We rely upon this support for our people, for the good things that USAID has done. And indeed, once again, group goes into a federal district court, this time again in Washington, D.C. And they get in front of a judge named Carl Nichols. You may remember him because he's been one of the judges who's also imposed a lot of sentences upon those January 6th rioters, those insurrectionists. We've talked a lot about Carl Nichols, U.S. District Court for the District of Columbia. For what it's worth, once again, he is a Trump appointee. And yes, indeed, Carl Nichols, late this past week, issued a restraining order, temporary restraining order, pausing this imminent administrative leave of 2,200 USAID employees and a plan to withdraw nearly all of the agency's overseas workers within 30 days. Mr. President, Carl Nichols says you can't do this. He also ordered the temporary reinstatement of 500 agency employees already on administrative leave by virtue of what the president has directed inappropriately, unconstitutionally, with respect to this independent agency. Carl Nichols, federal district court judge, guardrail like the other judges, coming in and late this past week ordering the Trump administration to halt, at least for now, some elements of this omnibus attempt to shut down the U.S. Agency for International Development. The unions that brought this lawsuit, they're the plaintiffs, had called upon the court to block this based upon this unconstitutional and illegal action, saying it had generated a global humanitarian crisis and, yes, threatened American strategic interests. That's what the union had said. Again, the union of employees here, they represent foreign service officers. Judge Nichols had said the unions had established the employees affected by the leave and withdrawal offers would suffer irreparable harm, as would others in our nation and around the world. Global humanitarian crisis threatening American strategic interests. Significantly, the lawsuit also said not a single one of the defense actions to dismantle USAID, and by defendants, we're talking about Donald Trump and his policy implementers, were taken pursuant to congressional authorization and pursuant to federal statute. Congress, once again, is the only entity that may lawfully dismantle the agency. That's the allegation in the civil complaint to bring this forward, and that's the concept with which Judge Carl Nichols has agreed. Filed this past week, again, the groups, the Democracy Forward and Public Citizen Litigation Group, and the American Federation of Government Employees, notes that the central role of Elon Musk, once again, in doing all of this and his hands all over this effort, now enjoined by a federal district court judge, at least for a while, until once again a court can entertain more information and argument about the legitimacy, if any, of doing all this. And we come back, yet another instance of more federal judges acting as safeguards of our democracy here on Amicus. This is Amicus, a law review. My name is Jim Santelle, talking today principally about the role of federal judges. Yes, federal judges in serving as the guardrails against many, if not all, of these administrative decisions, these executive orders issued by our president. We've talked about the ways in which multiple federal judges have told him, that is the president, that you cannot proceed with this birthright citizenship amendment to the Constitution. You cannot proceed, Mr. President, with this process for getting rid of federal employees in this incentive program, or at least not for now. Told him as well that when it comes to USAID, this huge agency responsible for international support and assistance, at least as to that, likewise, we're going to stay that. We're going to impose an injunctive order with respect to that as well. And indeed, there's another one. There are many others out there. This is a sampling, believe it or not, of the good work that federal judges are doing to uphold the law in America. This one coming just as we're going on the air here. A judge halting the access to that Treasury payment system by, yes, indeed, Elon Musk's team. A federal judge just Saturday, just today, as we're on the air, temporarily restricting access by Elon Musk's government efficiency program, those Doge people, to the Treasury Department's payment and data systems, saying once again that there is a risk of irreparable harm. That's the standard by which federal judges look at these things when they come in on these emergency applications. Will there be some harm that we cannot repair down the road unless I stop this from going ahead? The judge today saying, yes, indeed, that's exactly it. This is U.S. District Judge Paul Engelmeyer, and saying in particular that the new policy of allowing political appointees and special government employees access to these systems, which again, as you all know from the news, contains highly sensitive information like bank details, all of that heightens the risk of leaks and the system becoming more vulnerable than before to hacking. Judge Engelmeyer has now ordered that any such official who is granted access to the systems since the day the president became the president, you're ordered to destroy any and all copies of that material downloaded from the Treasury Department's records and systems. Get rid of it. And oh, by the way, if you don't do that, you're in contempt of court. Also restricted the Trump administration from granting access to these categories of officials. The defendants in that particular case, again, brought in the district court. The defendants, President Trump, Treasury Secretary Scott Bessent, B-E-S-S-E-N-T, you may be getting to know him as well, and the Treasury Department itself have to show cause, that is, come back into the courtroom on February 14th, yes, Valentine's Day, before Judge Jeanette Vargas, who's handling the case on a permanent basis. In other words, it was enjoined by Judge Engelmeyer. Jeanette Vargas is the one who's going to be having this substantive hearing. But until then, hands off, the judges telling these Doge officials. The order once again comes in response to this federal lawsuit filed by Letitia James. We've heard from her before. Of course, she is in New York. She is the Attorney General. 18 other state attorneys general across the nation charging that when President Trump gave Musk the run of these government computer systems, he had, again, breached protections enshrined by the Constitution and failed to, here we go, faithfully execute the laws enacted by Congress. That's the due care clause of the Constitution. The attorneys general saying the president had given virtually unfettered access to the federal government's most extensive information to this group of what we think are young aides who work for Mr. Musk, runs a program the administration calls, without, again, any congressional authorization, the Department of Government Efficiency, or DOGE. It's not an actual department, doesn't exist, not given any legal authority. The group supposedly assigned to cut costs somehow. Members are attempting to access government data to support initiatives to block federal grants from reaching certain disfavored beneficiaries. That's according to the lawsuit. The response from the defendants, including Elon Musk, publicly stated his intention to recklessly freeze streams of federal funding without warning, pointing to his social media posts in recent days. All of that happening just this weekend. Yes, indeed, a huge, huge breach if this were to continue, and also significant. Why? Because it's through those systems that everyone who gets federal benefits, Social Security, Medicare, all kinds of things, payments made in the Agriculture Department, Health and Human Services, SBA, all kinds of things, food stamps, all kinds of programs out there get processed again through the Treasury Department because they're responsible for getting the money out there. They're the ministerial agency that is responsible for getting money into the accounts of corporations and, yes, of private entities, not-for-profit groups, and individuals who anticipate those monies coming into their accounts. Again, this is a big victory for the folks who are pushing back on all this. Elon Musk, of course, also showing up at the Labor Department, trying to do the same thing. We've got judges looking at that as well. The upshot of all of this, all of these 4 cases, they're symbolic of many other things in which federal judges today, once again, are saying, no, Mr. President, you can't do this. And at a minimum, scheduling more hearings at which time there will be an exposition, testimony given, documents presented about not only what these orders are to the extent that they're understandable at all, but also the impact that they're having upon human beings in America, human beings across the face of the planet. Birthright citizenship, USAID, Treasury Department, this incentive program for jobs, all of them being stopped by federal judges, or at least for the time being, against the better advice of the advice, again, in quotes, of the lawyers who are surrounding Donald Trump. And I make that point just because many of the judges are also asking out loud, where are the lawyers who are surrounding the president? The lawyers, not the judges, the lawyers surrounding the president and saying, Mr. President, you can't be doing these kinds of things. Where are the lawyers? These judges are also asking. Well, apparently they're giving advice to our president that he can, in fact, go along and do these kinds of things. Federal judges saying, not so fast, can't do it. We have appreciated very much throughout our time on the air, of course, the calls and the comments from our listeners, and that includes just this morning. Delighted to have with me Kristen calling in from Waukesha here. Kristen, thanks for joining this conversation. Good to hear from you on our broadcast.
Hi, Jim. Good morning. All of this stuff that they're doing so rapidly, especially the USAID, I guess I'm just looking for your opinion. Are these people ignorant of the national security strategies that this agency holds together, or are they doing it on purpose to weaken our national security? Because this agency was put together with such care to really, like you said, maintain these bonds with our allies and make the U.S. a partner around the world.
Right.
And to just pull the strings out from that, it's really dangerous.
It's huge.
And I can't believe we're going to just let the Kremlin and China fill the void of the United States around the world.
Could not agree more, Kristen. Absolutely. And that's the point, right? Is that if you do these kinds of things, you're not only affecting, and I know the focus right now is on these employees, which are significant, right? These are people who, again, could get jobs, as you and I both know very well, could get jobs in a private sector making a whole lot more money, stay at home and do an awful lot of things. They've decided to take these jobs themselves to assist other people in foreign countries. And the related point, which you're also making, assisting these foreign nations and communities in becoming better. And so it's not just an economic issue. It's not just a workforce issue, as important as those things are. It is, Kristen, could not emphasize enough what you just said, which is it's a national security issue, and it is an international security issue as well. When we vacate the field, as you just said, others will enter. Those others who enter the vacated areas are not our friends. Those are the Chinas and the Russias and the North Koreas of the world. It is also internationally, it's an international policy disaster. And that's why so many people, including people in Congress on both sides of the political aisle, are responding to this not well and talking about the dramatic impact that this will have upon our national security. Humanitarian assistance, a huge in disaster relief, poverty relief, a huge amount of this. And again, this goes back. The other part of this, of course, is that the Congress routinely, Kristen, as you know, always re-ups the authorization for this. It started way back in 1961. The Foreign Assistance Act basically established the basis for the USAID. John Kennedy, that's right, he's the one who first put this executive order to establish USAID in place. It's been around since the Kennedy administration, Republicans and Democrats alike, including Ronald Reagan, who actually increased dramatically the budget for the USAID. Why? Because he did exactly, Kristen, what you said, which is he was concerned about the place of the United States in the world stage and felt that our national interests were in support of doing more to assist our allies and even those people who may be on the fence overseas. Ronald Reagan did that, and the Congress every single year re-ups the authorization of this thing, again, called the Foreign Assistance Act, and supports USAID. This is not done. This is not done by any measure. And the head-scratching question that you raise is the same one these federal judges are raising. Who's making these decisions? Who's making these recommendations about this? It is so ill-tempered. It is so ill-timed, of course, given what's going on in the world today, and even for the long run, hugely unproductive. We've got a federal judge who right now is at least for the temporary time, has said, we're not going to go ahead with this. There's a lot on the plate of that, involving employment issues, involving congressional issues to authorize, involving what USAID does generally. But it shows, I think, Kristen, and what others have commented about is the recklessness of this administration. All of these areas, this is a big one. All of them are big. This is a big one in terms of the future of our nation, the future of the planet. Thanks so much, Kristen, for your comment. Mark is also on the phone. Mark, thanks for waiting a very long time. Appreciate, as always, your contributions to our discussion.
Yeah, not a problem, Jim. I've actually gone out and kind of scanning through some of the comments that have been made about this stuff. It appears that people do not understand what USAID does. They don't understand what the Consumer Protection Financial Bureau does. They don't understand what the inspectors general do. Briefly to put it in place, it is just remarkable the level of ignorance, because most of these agencies have operated cleanly and effectively through the decades. They haven't raised any eyebrows at all, so people don't understand what important roles they actually play. And for the Supreme Court, going back once again to the Supreme Court, assigning kingly powers upon the presidency, it's precisely what, if I understand it right, what the anti-federalists were concerned with, and what Alexander Hamilton said: no, you don't need to worry about the king becoming a oriental potentate and be surrounded himself with minions and mistresses and have his army of janissaries he can send out to attack his political foes. But precisely, I think that is what we are seeing today, because with his pardon of the January 6th insurrectionist and in some cases treasonous people, that he has activated his own little private army that he could probably activate at any time, in addition to the ones that didn't show up on January 6th, would be in fully support of supporting Donald Trump in this. I mean, I could be wrong, but given Donald Trump's predilections, then what's to stop him now from declaring, like the old European lords, we see in popular literature, what Droit de Signor, and describe, well, if there's some young virgin I see I want to have, I just send people out to scoop her up, and
right.
Where the Supreme Court even decided that, that's okay. He's
right.
Maybe I'm being hyperbolic.
Well, no, I don't think so. I think, at the time of the issuance of this opinion back in July, and certainly that time, I've also sometimes said, I wonder if I'm being hyperbolic. And now we see the implementation of exactly what the Supreme Court said. And so it's not hyperbole, it's reality. And Mark, I appreciate very much your observation about all of this. And yes, indeed, that's one of the reasons why I have this broadcast, Civic Media, out there trying to educate, going deep in some of these issues, making people aware of the implications of these acronyms when it comes to agencies. Mark, thank you so much for that observation. When we come back, we'll talk about the Department of Justice and things going on there. And then finally finishing the program this weekend by talking about the Proud Boys and something that's happened to them at the hands of a Superior Court judge in the District of Columbia. Stay with us for that discussion. This is Amicus, the last segment of our broadcast this weekend. We're talking again about the rule of law. And one of those other safeguards that should be there, that is the U.S. Department of Justice. We'll see under the Biden administration whether or not there is any pushback, any tempering of some of these decisions coming out of the White House. That should be the role, in part, of the Attorney General. It certainly doesn't appear in the first few days of Pam Bondi's term as our Attorney General, our Chief Federal Law Enforcement Officer, that she is adopting that role. She was sworn in just this past week. At the time, the president said this. He says, I know I'm supposed to say she's going to be totally impartial. Yes, Mr. President, you should say that. With respect to Democrats, he said, but I think she'll be as impartial as a person can be. Boy, that doesn't give us a whole lot of satisfaction or confidence, does it, when it comes to her commission? Indeed, what has she done in her first days? Well, she's also spoken about serving Donald Trump and not serving the people of the United States of America. I recall very well when I was a U.S. attorney, one of the regular meetings that we would have in Washington, D.C., all 92 U.S. attorneys coming forward. We met with Barack Obama in the White House in the East Room. And I remember very clearly him saying to us, you know what? You are not my attorneys. You are not my attorneys. You're not even the attorneys, if you will, for that building down the way there for all of the other Department of Justice employees. You're not that at all. You're the attorneys for the United States of America, the people of this nation. We don't serve inside the Department of Justice the interests of the president. We serve the interests of justice. A difference from the past and this attorney general. What else has she done? She has certainly indicated the actions of Emile Beauvais in not only terminating prosecutors who were responsible for the January 6th and Mar-a-Lago cases, terminating the prosecutors in the D.C. U.S. Attorney's Office who were responsible for prosecuting those 1,600 people responsible for the insurrection on January 6th. None of that's going to be turned back at all. She's also got on her desk, of course, this effort to try to address whether there are federal FBI agents who should be terminated. That's going on right now under the auspices of the acting Deputy Attorney General, Emile Beauvais, likewise affecting the legitimacy of the rule of law force internal to the Department of Justice. She's done some other things. She's done a number of other things as well. That includes basically shutting down what has been called a DOJ task force targeting Russian oligarchs. These people are attempting to undermine the safety and security of our nation. Established under the prior administration, we're going to stop that from happening. We're no longer going to be addressing whether Russian oligarchs have an influence inappropriately in our government. She is also, however, establishing another task force. This one has to do with religion. She is establishing, again, announced just this past week by the president, an executive order creating a Justice Department task force to eradicate what he called anti-Christian bias within the federal government. The mission of the task force, according to the Attorney General, is going to be immediately halt all forms of anti-Christian targeting and discrimination in the federal government, including the Department of Justice, the FBI, which is the Department of Justice, the IRS, and other agencies, will work to fully prosecute anti-Christian violence and vandalism in our society. That also announced by the Attorney General this past week. Again, we'd like to think that our Department of Justice, the White House, would embrace the diversity of all religions without establishing any of them, without breaching that line between government and religion, and that every religion, whether it is a Christian faith, a Hindu faith, a Buddhist faith, a Sikh faith, is Islam, Judaism, Sikhism, whatever the faith is, all of them are a part of our national experience. None of them should be impacted in any way by an attempt by the government to establish religion or even to promote one above another, which seems to be the approach of this task force. What else is the Attorney General doing? Well, we know as well that she has all but basically reinstated, giving a new life to the federal executions, the moratorium put in place by former President Biden, who ended federal executions and prevented those from going ahead. She has ended that. And so we can anticipate more federal executions happening. She has ended all diversity, equity, and inclusion efforts within the Department of Justice and required all employees to come back to work. No more remote work by February 24th. All of that happening inside the Department of Justice. Huge impacts as well upon our National Security Division, restricting and limiting the ways in which they do their work. Huge impacts as well. Some new policies with respect to environmental work as well. The Environmental and Natural Resources Division, that happening too inside the Department of Justice. We'll talk more about that and the further implications of the Bondi administration, the new Department of Justice, as future editions of Amicus, a Law Review, are broadcast. Finally, this news item, also at the hands of a judge. The Proud Boys, again, responsible for much of what happened on January 6th. Many of them have their sentences commuted. A pardon issued to Enrique Tarrio, this fellow who was given a 22-year prison term on charges of seditious conspiracy, pardoned by this president, receiving a full and unconditional pardon, commutations of other sentences imposed upon this group that is plainly responsible for an awful lot of what happened on January 6th. Proud Boys no longer have control over their own name. Under a ruling that was just issued this past week by Superior Court Judge Tanya Jones Bozier. She is in the District of Columbia. She is effectively a state court, although D.C. is not a state. She's basically a state court judge. Effectively means that the Proud Boys chapters across the country can no longer legally use their name or the group's traditional symbols without the permission of, wait for it, the church that was attacked by the Proud Boys in June of 2023. The church was attacked. It was the Metropolitan African American Methodist Episcopal Church. Under this ruling by the judge, the infamous far-right group was stripped of its control over the trademark Proud Boys and was barred from selling any merchandise with either its name or its symbols without the consent of this black church in Washington that its members had previously vandalized. The church had won a $2.8 million default judgment against the Proud Boys, and Enrique Tarrio, several of the subordinates as well, attacked it in a night of violence after a pro-Trump rally that took place at the church. Now, as a result of judges once again enforcing the rule of law in America, this one a state court judge, a trial court judge in Washington, D.C., the rule of law upheld. All of that a part of our continuing discussion here on Amicus, a Law Review. Appreciate so much your participation in our discussion and invite you back again next week as we continue to address law and government and the aspiration for justice in our nation. Have a good week, everybody.